Hi, and welcome back to Beyond the Gavel. Now, there are lawyers who handle cases, and there are those who carry them. In this episode, I'm joined by Robert Godosky. He's a managing attorney with Godosky and Gentile, whose career spans more than 3 decades at the sharp end of personal injury and medical negligence litigation in New York. Robert has spent his professional life representing individuals and families whose lives have been irrevocably altered by failures of others. Now, his experience is not theoretical. It is forged in a courtroom where he has taken complex cases to verdict and secured substantial multi-million pound awards. So what's going to distinguish this conversation is not simply longevity, but perspective. He has seen the evolution of medical negligence litigation, from changing evidential thresholds to the growing complexity of expert testimony. And he's remained at the forefront, both as a trial lawyer and, more importantly, as a leader within the profession. His appointment to the board of directors of the New York State Trial Lawyers Association and his consistent peer recognition reflect that standing. So in our discussions, we're going to explore how experienced practitioners make early judgments on cases, what truly differentiates a strong expert from a superficial one, and how one sustains both standards and resilience over a career measured not in years, but in responsibility. This is a conversation about judgment, experience, and the weight of acting for those who have nowhere else to turn. So, Robert, thank you very much for joining us today on Beyond the Gavel.
Thank you very much, Peyton. Pleasure to be here.
Now, give me a bit about your background. How did you get into law in the first place?
I guess to a great extent, I was born into it. My father was a very well-known and prominent personal injury lawyer, initially on the defense side for many years, and then moved to the plaintiff side. And he and a partner from another firm opened up a practice, Godosky and Gentile, 32 years ago. And I was practicing with another personal injury firm for about 8 years, and he came calling and said he needed some help. And I joined the practice in 1996. And I've been doing that at Godosky and Gentile for 31 years.
And how did you get into medical malpractice?
I think medical malpractice has always been a very significant part of most of the personal injury firms, although over the past, probably longer than I think, but probably 15 years, it's become more difficult to manage those types of cases. So a lot of the personal injury firms no longer handle medical malpractice specifically. They'd rather handle the general negligence, automobile, trip and falls, which we always do, and we still do. The malpractice cases, the state law limited attorneys' fees on malpractice cases at the behest of the medical industry. They have a very powerful lobby, and they do a good job. Further, the firms that defend those cases are, quite frankly, quality lawyers. Have a great deal of respect for them. They do their job, we do ours, but some lawyers found that the expense and the fees, the benefits to the firm, were just not worth pursuing them. The firm I worked for before I came to work at Godosky and Gentile did a lot of medical malpractice. In fact, my first case I tried, which is very unusual, was a medical malpractice case, and sort of whet my appetite for a little bit more of the challenge in that area, and learning medicine for someone who was absolutely despised science growing up. So the concept of medicine was alien to me before, and now I have friends call me with medical questions, and my first answer is, go ask a doctor, please, please ask a doctor. But it has been interesting and challenging. As I said, they are much more vigorously fought by the defense carrier and lawyers. But it is still something that we do a significant amount here, but we are very, very careful on the intakes of those cases. In New York, which is really where my practice is almost entirely, you're required to have an expert find merit in the case. So they must review the records, and it has to be an expert in the field of the defendant. So if you're suing an orthopedic surgeon, you're going to have an orthopedic surgical expert tell you that upon reviewing the records in that case, that you have a case that is worth pursuing, that there was departures or medical malpractice. And you have to find an expert who's going to give it to you straight. I remember years ago, an expert once asked me, how aggressive do you want me to be? And I said, I'm not exactly sure what you mean by that, but I want you to give it to me straight. Don't be aggressive to find me the case because I'm going to pay for that at the end, and I will have paid a lot of money in processing that case. So getting a quality expert and pursuing it that way is an initial expense, but it's one that's well worth paying to make sure you're not taking a case that you're going to carry for 2 to 3 years and then get kicked out of court.
Yeah, I think that's very important, isn't it? There are two things you came up with there. One is medicine is a science, but people think science is yes, no, it's not. It's a statistic. And so, the likelihood of penicillin treating something is a statistic. It's not, it will treat it, it won't treat it. It's an experiment. And one of the things doctors have to learn is that it is that you can't just, one and done. You've got to, if you're doing it, it's an experiment with a patient. And you've got to keep your eye on what's going on and see, are they responding the way you want them to respond? Are they not? And then alter accordingly. And of course, that reflects in your expert and their opinion. If they, my job as an expert is for the court, basically, and is to keep it down the middle. Your job is to advocate for your client. And there is always going to be a tension. Isn't that correct?
Oh, absolutely. The point of an expert, and I think the focus, if I can focus it for a moment on what you touched on, which is really sort of a judgment issue, and that's always an ugly word for plaintiffs in this field because judgment assumes reasonable conduct by the physicians, and we don't punish or make claims against physicians for exercising reasonable judgment. They have to step outside of that ability or that decision and really depart from what's considered good and reasonable practice, which would be good and reasonable judgment. So if a physician can give, as you mentioned, penicillin versus another medication, chooses one that causes injury, there's really not a case in that instance. However, if it's documented in the chart that this patient has a very significant allergic reaction to penicillin, and the doctor says, I can give one of these two drugs to a general patient, just a person, rather than looking at the specifics of that patient, that's a huge difference. And you need an expert who's going to look through the records as carefully as you are, but with the eye of the medical standards.
And that's the point, isn't it? It's
Oh,
a
absolutely.
reasonable standard. You're not perfect. I'm not perfect. Nobody's perfect. And unfortunately, that's the way it is. But of course, clients don't see it that way. They have been treated for something and they feel hurt. Something has happened and they're not happy with the result.
And they
Uh,
are.
and they genuinely walk in and feel hurt. And
Oh, yeah.
therefore, two things, some of them are coming for the throat and say, I want you suing this. And others are actually just looking for a second opinion as to what's happened and do. So, how do you help a client understand right up front the art of the possible? Or how do you get them a medical opinion without paying for it, through the nose?
Well, I think you're juggling a number of things. You are juggling being a therapist. You are juggling being a realist, and of course, on top of it all, you're juggling being an advocate and an explainer as a lawyer. So yeah, there are a number of cases where it may look like a case to me and to my partners, and we pursue it and we get an expert to review it. And if it's a significant enough case and we have a fire for that case, we may go to more than one expert after one expert says, I don't see a case here. And we pursue that. And when we ultimately run that gamut and find that there's no case, we have to spend some time explaining to a client who is understandably angry at the medical profession, specifically one doctor or a hospital, and is almost always suffering from some injury, um, what the complexities are of the case. Because unlike an automobile case, in a malpractice case, you go in and you see a doctor because there's a problem. So you start off with some medical condition, and then the claim is that the doctor was negligent and caused a worsening of the condition or a completely different condition. But ultimately, you already went in for whatever the problem was. The classic example is always a failure to diagnose cancer case. It's inherent in that statement, a failure to diagnose cancer. No one's saying any doctor gave it to you. It was a time factor. And what lawyers have to be able to do is to explain to clients that the damages are that which the departure or the negligence uh, added to the condition. So clearly in cancer, if an earlier diagnosis would have cured it, if that's still a word that could be used in that area, then that's the damage. But more often it is a less invasive treatment plan, certainly a longer life prognosis, and those are critical. But for sometimes, clients want the blood, and we spend a lot of time early on in our intake, not only in evaluating the medical aspects with experts, but with the clients and trying to feel out whether we can serve their needs in obtaining justice. It's a big
I
word
love
when
what you said there about working with them and being, I think you allude to being therapeutic with them. And part of that therapy is listening. One of the problems sometimes with the medical side and an institutional side is listening isn't sometimes the best skill that they've got. And some can be very didactic, and you know that in the law profession, some can be very didactic and they're better suited to maybe doing contract. You get the same with doctors who are better suited doing postmortems, that they're not as good. And especially, I have to say, it's coming with this generation who are used to television, who are used to, remote learning and all, and they're not close in terms of relationship with their patient. And therefore, what you're providing, that therapy of listening, how important do you think that is, your relationship and your listening to what's going on in your ability to manage a client expectation?
Oh, it's everything. It is one must be able to, as I said, juggle being a therapist in some ways and talk to the client and listen to what they really are looking for. And there are plenty of clients who we talk to who the injury's either resolved or they've done very well. And it's not a question of whether or not there was a departure. We can pretty much find that there was, but their anger towards the profession, towards the doctor, and the ability of us to provide what they want has to be the same. And it is inherent in the relationship that we have with our clients that they understand what our limitations are. We can't cure the condition. We provide monetary compensation for the injuries, hopefully restoring a lot of what that client's missing in their life from the injury, um, provide them some safety net if they can no longer work. But if you don't have a good rapport with the client, you will ultimately fail with that client, even if on the black and white of evaluating how that case was handled, you may have succeeded. Getting a lot of money for the client, for most lawyers, people would say that's a success. How the client must have been so happy. And sometimes, that's really not the gauge. I learned a long time ago that clients who are severely injured, it's not happiness. They realize that we can't provide that. We provide monetary compensation that hopefully is reasonable and fair and provides them some comfort level. But if you don't have an ability to listen to them and understand what they're looking for and be able to explain that, you're going to fail.
Yes, it's a fascinating. I mean, down in Florida recently, and there are these posters up, and somebody smiling and say, X got me 15 million. And I'm sitting looking at that and said, if you got 15 million for a case, you're not laughing. There's something bad going on. And the poster that shows this smiling person, thank you, with their thumbs up for 15 million, just isn't on. That's not the reality of where it goes. And yet sometimes lawyers advertise that, which then puts, somebody who's lesser injured thinks these mega bucks are coming. And I know that's not what's going to happen. You got to manage that, you know, quite early on. So
Oh,
who
absolutely.
does that management for you? Are you in the front door? Do you have somebody else in the front door? How do you advertise and bring people in? Where's that interface start?
Our advertising is fairly uh, limited, even in this market. We have always been on certain lists, um, none of which we pay for. Um, we've upgraded our website to be more of an informational source. You're not going to see us or our clients with thumbs up saying, Godosky and Gentile. We have reviews. I know that our managing part, our manager, office manager, will send me the reviews when they come out, and um, it's word of mouth. My father and Tony Gentile both developed very good reputations in the courts, um, and a lot of our business has come from white shoe Wall Street firms, defense firms. Uh, One of the things that, again, my father and now my brother has worked in is representing lawyers and judges in their respective disciplinary firms. That gives our firm, a good reputation in terms of our straightforward honesty and integrity. And to me, that is uh, sort of the flip side of showing the client who says $15 million. Look at me. And he's out looking uninjured, and that's a lottery winner, and not a plaintiff injured victim.
You're absolutely right. So when that's what drives them to you. And of course, the people you know personally or have close association with. But who sees them first? Who takes the first, uh, you know, contact with them? And how does that work out? Do you train paralegal staff to do that?
It's
Have
almost
you
always
telephone answering? How does that happen?
well. There's a lot of telephone answering, but it's almost always done by an attorney.
Right.
There are 8 attorneys in my office. We all intake cases. Again, they may be divided where me and Pasquale Viro, David Godosky, Tony Gentile, Will Gentile may take the majority of the medical malpractice cases, and then for us, as well as the other 3 attorneys, will frequently take the general negligence cases. Um, but we get an attorney in on those cases very quickly, whether it's going to see the client, having the client into the office, which, of course, since COVID has been a little bit rarer, but we've all learned how to do Zoom, and it's not ideal, but it does work. But we do communicate lawyer to client on pretty much every case. We do have a on-staff investigator who handles signups and details some of the intake process. But again, that's almost always in person. And there's a contact because, like you said, learning the client's expectations is tantamount in evaluating what we can provide. And as I said, we're very selective. So there are cases where we feel that we're not going to be a good mix or match, I should say, for that client, um, because his expectations or her expectations are that they want punishment. And I've directed numerous clients to the Department of Health. File your complaint with them, with the state. Um, as egregious as it might be, um, uh, the physicians boards, where penalties can be assessed, but that's not going to give you any compensation. And the reality is most of them are looking for the compensation, although we have to obviously gauge their expectations on that too. But we have turned down cases that I think probably are solid cases. I think cases that they would certainly. I'm sure that those clients found lawyers very quickly, but we felt that it was not a good fit, and that we could not interact with that client in a manner that was going to provide them with the services that they needed. And
Yeah,
it,
isn't it? Globally, in Australia, United States, Toronto, Canada. UK and Ireland, I mean, universally it looks at about 20% of what walks over your door is liable to be a decent case, or liable to at least to have a chance.
On the
And a
medical,
lot
it's
isn't.
less.
So how do you? Yeah, I agree with you. I mean, in my own knowledge and practice, it's about 5 to 10% that
Right.
actually go on to succeed. So, and you're running a business. I mean, you said, well, look, I've got to get an expert on this, and I was an expert cost 3 to 10 grand, somewhere around there, depending on
Exactly.
what it is. And your firm could bankrupt itself pretty easily by taking on case. So how do you sift them to begin with before you decide to spend dollars getting that opinion?
Yeah, I mean, I think that falls on the lawyer's experience very often. I think that we can look at cases, and granted, I can look at a case from an injury standpoint and know that the injury is not large enough, um, regardless of what the malpractice might be, for my office to spend time on it. And as I said, we try to keep our caseload manageable. If we were taking in every case, the expenses would be more, the risks would be more. Uh, by keeping them small, we are able to both first look at things like that. So there can be a malpractice where it was egregious. And essentially, the doctor, in our initial view, lucked out because the client walked away without really any significant permanent injury. The client sees the malpractice and is angered, and we see the fact that you should be one of those people who's saying, whatever they got me, I'm fine, thank goodness. And we can reject that case out of hand. But the lawyers really do that review. And we do the review because of our experience in the medical field, looking through the records. We get the records, we look at them, and we get a sense of where is this departure. And I tell you that clients running the gamut of experience and education have a very good sense of what happened to them, whether they were told or not. And they will say, I went in for this procedure, and this is where the mistake occurred. And then, assuming that there is a significant injury, they can explain that. And we can look through the charts to find out whether or not those errors are at least present in the chart, to the extent where we're saying, you know what, the injury is significant, something's missing in this chart that I need to get the medical expert on, and then we take that step. But there are plenty of those cases that, after expert review, where they find there's no departure, we cannot start that case. And yeah, we have spent, as you said, $3,000 to $10,000 on the review, the records and the review, and hopefully have balanced that out enough to be able to make good judgments. And so far, we've succeeded in doing that over 30 years.
How do you find, I mean, obviously the new generations coming in, there are all sorts of technology, and particular coming in now is AI. How do you see AI impacting on what you do?
I probably cannot reasonably estimate how much it's going to impact our business. Uh, but I do see its use in providing the lawyers in my office synopsises of medical records, uh, timetables, uh, to be able to initially discuss with the client, on intake, um, what transpired, to see if what their recollection is matches the records. So putting the medical records into a closed AI program has been very helpful for our office. Um, we Everyone knows about the hallucinations and medical and legal briefs. We do not use it for legal briefs. We do not use it for legal documents. Document creation is coming in many fashions, whether it's AI or template, which is a form of AI. Um, but I certainly have used it at length to go through a 4,000-page medical record to tell me, the medications. Um, I do not rely on it. I still spend the time going through the 4,000 pages, but with that and with other search capacities, it certainly does save me a lot of time. And that's going to be the area that, you know, I've been doing this now for 37 years. And I think by the time that I'm ready to hang it up one way or the other, I don't know, lawyers don't actually retire, right? Um, but yeah, AI is going to be something I'm going to have to figure out exactly how it fits into every aspect of my business and in my life. Um,
Yeah. Have you people coming behind me, family or anybody else coming in after you? I mean, you followed your dad.
and my brother
What?
followed our dad, and he and I worked together very closely. Um, no, I do not. Neither does my brother. Uh, I certainly, I think, was at the stage when my kids were born that this business started getting more difficult than it was even before. Um, we deal with in New York, we deal with Albany trying to legislate certain things against us. I remember my father going to Albany when I was in elementary school to fight the no-fault bills because they felt that that was going to destroy the practice. He ultimately, and we all agree that it's been a good thing as a overall. But now, they're trying to deal with automobile coverage in New York, and Uber is a huge, huge problem on the horizon. Um, it, it, I felt that both my sons had interests outside of this practice and had more fire for areas outside the law. So,
It's not the truth. I mean, it's in any walk and anybody with a business. I mean, is your family going to follow you into it, or what are you going to do with it?
right,
How are you going to exit?
pass it on. Yeah.
And that's always. I mean, you're facing that. I'm facing that. My family are medical, but they're in widely disparate places and all the rest of it. So it's interesting how that's working.
Oh,
So
it's
if you were to talk to a young person, like my students, for instance, coming through, what would you want to tell them? What do you wish you'd known at their age before you started all this?
um, Well, I think that I did know because I did see my father, although his reputation was such that there were times where I went with him to court and could not see him do anything but chit chat with lawyers and judges, and then we'd leave and he'd tell me all the things he completed. And I couldn't figure out how he did that, but I do know how hard he worked, and I knew that it's a lot of work. Um, there's there's a good feeling to help people, so I'm very proud of the work that my father did, that I do, that my firm does to help families after these things. But I don't think that a lot of the young people realize how much work is involved to provide that type of representation. So when we talked about, on intake and explaining to the client, what they can expect and to try to manage those expectations, I think that part of the upcoming generation, the difficulty that I have in explaining things to lawyers who I talk to, who I do on continuing legal education programs, is you have to get into the courts, and there's an obstacle that's pushing back on that, which is you know um, uh, remote handling of intake, a remote handling of conferences, remote handling of depositions. Uh, on occasion, you know, I will compel everyone to come in and have a deposition in person. I find those to be more valuable, but I'm running up against the defense bar that says I can sit in my office and do a deposition that I used to drive an hour and a half to get to. I don't have to do that anymore. Interacting in the courts, in conferences where you're meeting judges and lawyers and talking to them, not just during the conference, but afterwards or while you're waiting, um, an art that is dying. And that is, I think, the biggest obstacle to young lawyers becoming entrenched in the profession.
I think that's perfectly true. What is the old statement? A good lawyer knows the law, a wise lawyer knows the court. Those relationships that you've built up, that you saw your dad using, that you obviously use, and also the other side of it, that's the communication side, but the other side of it is that the laws of business, and you have to understand that. So some people go entirely the other way and want to help the earth, no matter what, and you can't tolerate that either. You'd be out of business, and you've got that's a balance that has to be struck, hasn't it?
Ah,
between your thought, if you're having empathy, not sympathy, listening. And doctors need to know that too, about
oh,
listening
yeah,
and hearing. Better than listening is to hear, and to be
absolutely.
able to respond to people. And then also you got to get these young people to understand, that it's not. One of the things we found in other things like dentistry and stuff like that is that young people come in and don't want to take the practice. They want to work and go away.
Yeah.
So you're left with the practice say, well, I want to work, for you, and I want to work for Godosky and Gentile, but I don't want to be a partner. I don't want to buy in. I don't want to do anything. And you're left sitting, and what am I supposed to do, when I want out? So your exit plan has to be thought. Have you thought about an exit plan?
Um, well, I guess we don't have an exit plan. We're in the process of moving to new space, so we're signing on to a lease there. Um, my father exited when he passed away. That was how he did it. Um,
Bit extreme for you to say that.
it's
That's the way
it's
I.
extreme at this point. He was 89 years old and had practiced up until that point.
He
If
kept
you
his
if
brain
you want me
active.
to,
That's very
yeah,
important.
if you want me to sign on for that now, I would 89 and you know go out like that. Uh, there is no specific continuity plan, but I consider myself still a young lawyer. My brother's a couple years younger than I am. Tony Gentile is older, but as active as unbelievably active and doing great. And William Gentile is his son. Pasquale Viro is his son-in-law. Um, we work we work well together. We consider it a family and
Good partners, having the
good
same
partners.
values, that's very, very important, isn't it? I mean, I was talking to somebody
Critical.
else earlier on, and partnerships have become the problem. But if you can find good partners and work with them because they have the same values as you have, and that
Right.
again is something the younger generation have to. Look, this has been a wonderful chat,
I
Robert. I
really
have
appreciate it.
really, really enjoyed it. Thank you so much for coming on. I think our listeners would have heard a lot from you about how you grew and developed and how you work on a practice and your method of looking after people. And you've proven yourself to be so successful in those outcomes that you've had on behalf of your
Thank you.
clients. And then also that, as you alluded to, you spend time to teach, and you are, on the board of directors of the State Lawyers Association. So you give back and you add value, and that's an important lesson for everybody. Robert, thank you very much for spending your time with us today and Beyond the Gavel, and I wish you every success in the future. And I hope New York's weather gets a lot better.
Thank you, Pete. I appreciate the time.